Good morning. Happy Tuesday. I am in my third out of 6 depositions this month. If anybody ever tells you to get involved in construction law, tell them no, because this is a lot of work for a expectation of some income in the future. I say expectation loosely because you never know how these things are going to go. I think my client will win, will prevail ultimately, but will he get $1 or will he get, what are we looking for? I think it's like $400,000 or something like that we're suing over. So who knows? Who knows how much he'll get? The commenter who I spent a large chunk of time on my last video responding to is back in my comment section. My comment section is a mix of people who don't understand things and autists who are trying every possible permutation of broken clocks not being right twice a day. I guess some people need to feel important or something. I don't really understand why people do that, but okay. I mean, if it gives you a sense of importance to hypothecate on when broken clocks aren't right twice a day, then sure, I guess, knock yourself out, have fun. Anyway, the two things I was responding to that this other commenter had said were his assertion essentially that you can't commit a crime against a public employee, which is nonsense, and his assertion that the DA allegedly alleging that Myers and the victim had a prior romantic relationship to the grand jury when they were determining probable cause, somehow taints the entire prosecution. But again, I don't know. The DA has to prove probable cause for each element of the crime to the grand jury. Only the elements of the crime really matter. That's it. The color of a bystander's socks don't matter. What the cop had for breakfast that morning doesn't matter. The elements of the crime. I don't know what all the elements of the crimes that the grand jury alleged, or the DA alleged the grand jury were, but like your classic burglary, you have to prove breaking and entering at night into the dwelling house of another person with the intent to commit a felony therein. Those are the elements. You have to prove each one of those. That's what the DA is there to do. If the DA says that there was a prior romantic relationship between the victim and the defendant, that's not material unless the DA is trying to get in Arizona, the DV tag onto the crime. That's where they basically, it's like it heightens the potential punishment for a crime. And the DA wasn't trying to do it. He wasn't charged with stalking as domestic violence. He wasn't charged with harassment as domestic violence. He was charged with stalking and harassment. So it's not material. I don't know how to explain that in a way that Lane Myers supporters will understand, but it's not material. So anyway, this fine gentleman comes back in with the rejoinder, fruit of the poisonous tree. Fruit of the poisonous tree is a doctrine about the suppression of evidence that says if you violated someone's rights to get the evidence, the court can then suppress that evidence for no other reason than you violated someone's right to get it. The classic example is when the cops don't Mirandize the suspect and they force a confession out of him, and he says, yeah, the body is in that field. Because they didn't Mirandize him, that suspect, now defendant, is probably going to file a motion to suppress that evidence because it was obtained in violation of the defendant's constitutional rights. And there's various defenses to that particular motion to suppress. The cops could say, we were already searching that field for the body. We would have found it anyway because we were already searching the field for that body. So the confession really didn't change anything. Maybe it'll work. Maybe it won't. Who knows? I certainly don't. But it has nothing to do with the DA allegedly alleging that Lane Myers and the victim had a romantic relationship prior. Nothing to do with it. Completely different doctrine for a completely different thing. I point this out because, again, I don't hate this guy. He's misled. He's been listening to stupid people tell him things he wants to hear, and I am just happy that he's in my chat, listening to my videos, and maybe getting a little bit better grasp on how these things play out. Instead of accepting that, though, he rejoins with falsus in uno, falsus in omnibus, a classic saying, a maxim of law that says essentially, if the jury finds that you've lied about one thing, they can infer you've lied about everything. It goes to the credibility of the witness. Of the witness. It goes to the credibility of the witness. You may be saying to yourself, but John, the DA is not a witness, the DA is an attorney. And that's an excellent point. Falsus in uno, falsus in omnibus is a doctrine, a maxim, of law that you would typically incorporate into a jury instruction, that if you find the defendant lied about one thing, you can infer the defendant lied about everything. And there will be a big fight between the prosecutor and the defense attorney about whether or not that instruction gets in, and if it does get in, how it's worded. I mean, there's going to be a big fight about that, but you can try to get that jury instruction in due to it being a maxim of law. But nowhere in there does it apply to a DA, because the DA is not a witness. The DA is not presenting evidence. The DA is presenting witnesses who then present evidence through the form of testimony, through authenticating documents or videos or things like that. The DA isn't going to testify. So falsus in uno, falsus in omnibus does not apply. There is no doctrine that this guy can name that turns that allegation, even if true, into an invalid prosecution. There just isn't. At least that I'm aware. Maybe Arizona has some weird peculiarity I don't know of, but there's just nothing there. And if there was something there, again, you still have to contend ultimately with the fact that Lane Myers pled guilty. Any defense he could have raised based on that alleged false allegation is gone. You're jousting with windmills. You're tilting at windmills. You are Don Quixote. Your protestations are farts in a windstorm. They're meaningless. The only reason why I'm trying to correct you on it is so that you maybe understand a little bit better about why Lane is in the position he's in, about why Lane chose to plead guilty. Lane Myers probably knows more about the law than his idiot followers. That, again, is not a compliment to Lane Myers. That is an insult to Lane Myers' followers, but it's true. It's probably true. You're not going to get a lot of lawyers following Lane Myers to try to learn shit from him, but you do get these other people who think that Lane Myers has something to teach him, which is why he has subscribers to his Law Office of Lane Myers channel. That's why he has subscribers, because they think they're going to learn from him, because he knows more than they do. But if you get your information from garbage sources, garbage in, garbage out. Sorry, Lane Myers had a better idea. He was advised by an attorney. He had plenty of opportunity to do his own research. And despite that, he had access to all the evidence that the state was going to use to produce a trial, to get a a guilty conviction. And with all of that knowledge, he chose to plead guilty. That should tell you something about the quality of the state's case. That should tell you something. Rusty Moore, someone commented on a Rusty Moore video. They were upset that his GoFundMe was still going and that he might be dead, allegedly, something about funeral expenses, blah, blah, blah. But again, Rusty Moore was another one of those. Like, Rusty Moore chose to plead guilty. Why did he choose to plead guilty? Because the state was going to be able to convict him. Everybody's talking all this smack about this expert that never appeared and never testified. He pled guilty for a reason. He pled guilty because he was probably going to lose. And he knew that. And his lawyer knew that and probably told him that. You guys have to put a little more credence into a guilty plea. If someone pleads guilty, that means they probably think they're going to lose. Whether they did it or didn't do it, if they plead guilty, it's because they think they're going to lose if they go to trial. And so they're just trying to secure a better deal. Because they think they're going to lose. If you think you're going to win, you're unlikely to plead guilty. That's just human nature. No one wants to have a conviction if they think they can get out of it. And a public defender is free. I mean, it's just costing you time. Anyway, I've rambled long enough. I still have like an hour before I have to be in there. Thanks for watching. Have a great day.